Gary DeWaal here, and this is Bridging the Week for September 14th to 18th, and today is September 21st, 2015. Good morning. Last week was a week of many firsts in the financial services industry worldwide. For the first time, the Commodity Futures Trading Commission formally indicated that virtual currencies were commodities, and that swaps based on Bitcoin must be traded on a swap execution facility or a designated contract market. In addition, the CFTC brought its first enforcement action against a swap dealer for failing to file, as required by regulation, accurate large trader reports for certain swap positions involving physical commodities. Finally, the London Metal Exchange proposed position limits for the first time, too. We have a lot of firsts to cover this week, so let's get started. The Commodity Futures Trading Commission filed and simultaneously settled charges against Coinflip, Inc. and Francisco Riordan, its founder and chief executive officer, for operating a trading facility for Bitcoin options known as Derivabit without it being registered as a swap execution facility or designated contract market. According to the CFTC, because Bitcoin and other virtual currencies are properly defined as commodities under applicable law, all trading facilities for commodity options and other swaps must be registered with it as a SEF or DCM, said the CFTC. Since from at least March 2014 through July 2014, Coinflip operated Derivabit as a trading facility for Bitcoin options without proper registration, it violated applicable law, claimed the CFTC. Additionally, said the Commission, Mr. Riordan was liable for Coinflip's violation as its so-called controlling person. To resolve the CFTC charges, Coinflip and Mr. Riordan agreed to cease and desist from violating applicable law. No financial penalty was included in the settlement. The Australia and New Zealand Banking Group, Ltd., an Australia-based Commodity Futures Trading Commission registered swap dealer, was charged by the Commission with violating regulatory requirements related to the reporting of large swap positions involving physical commodities. According to the CFTC, from at least March 1st, 2013 to November 20th, 2014, ANZ failed on certain days to submit any reports of its large positions, while at other times it routinely submitted required reports that included errors. Under applicable law and CFTC regulations, swap dealers and other reporting entities are required to file with the Commission on a daily basis reports of swap positions involving certain physical commodities in excess of certain minimum levels in particular formats. Among other errors, ANZ, prior to September 2013, failed to identify any relevant commodity, throughout the period populated the field commodity reference price in a manner different than required by the Commission, and throughout the period reported positions in units of the relevant commodity rather than the futures equivalent level. ANZ agreed to pay a $150,000 fine to resolve the CFTC's complaint. Alexander Milrood, who earlier this year was charged by the Securities and Exchange Commission with engaging in disruptive trading activity known as spoofing or layering in connection with high-speed purchases and sales of various exchange-traded securities from January 2013 through January 2015, agreed to plead guilty in a related criminal matter brought by the U.S. Department of Justice. According to the SEC, Mr. Milrood, a Canadian citizen who resides in Ontario, Canada, and has a residence in Aventura, Florida, used other traders, primarily in China and Korea, to place multiple non-bona fide orders for stocks to induce other traders to trade on one side of the market at artificially inflated or depressed prices, and then to cancel the orders. Mr. Milrood and the other traders engaged in the strategy to effectuate orders to purchase or sell the relevant security on the other side of the market at favorable prices, charged the SEC. In connection with this criminal action, Mr. Milrood will plead guilty to one count of conspiring to commit securities fraud and face imprisonment of up to 5 years and a fine equal to the greater of $250,000 or twice the gross amount of any profits he made from his trading. Mr. Milrood's SEC action remains pending. Thomas Hoenig, Vice Chairman of the Federal Deposit Insurance Corporation, defended the inclusion of certain exposures of banks to clear derivatives, including through the clearing activities of their Futures Commission merchant affiliates, on behalf of customers. In the calculation of their so-called leverage ratio in a speech on September 16, 2015. By the way, the leverage ratio refers to the amount of shareholder equity and disclosed reserves a bank maintains divided by its total exposures. According to Mr. Hoenig, quote, the clearing mandate was not a mandate to weaken the prudential regulation of banking organizations as a means to stimulate the derivatives business, end of quote. Mr. Hoenig rejected the argument that cash received from an FCM's customers for initial margin should be excluded from a bank's calculation of its exposures because an FCM only acts as an agent for its clients. This is not the case in Mr. Hoenig because FCMs can ordinarily invest customer cash deposits and earn income. However, Mr. Hoenig indicated that a bank could exclude customers' cash deposit as initial margin with an FCM affiliate if the agreements between the customers and the FCM eliminated, quote, any right to investment income from the collateral, end of quote. Mr. Hoenig noted that, quote, institutions have done this, end of quote. However, Mr. Hoenig proposed no means for a bank to exclude from its total exposure calculation affiliated FCM's guarantee of client performance to clearinghouses. According to Mr. Hoenig, quote, such guarantees, whether for derivatives or other obligations, are included in the leverage ratio to ensure that banks do not move significant sources of exposure off balance sheet, end of quote. 4 former officers of now defunct Penson Financial Services, Inc., once the second largest clearing U.S. broker-dealer, and of Penson Worldwide, Inc., its publicly traded parent company, were charged by the Securities and Exchange Commission with a series of accounting and disclosure failures relating to Penson Financial Services' extension of margin loans to certain customers in excess of amounts permitted under federal securities law. According to the SEC, Penson made approximately $100 million of margin loans between 1999 and 2008 to Christopher Hall and his affiliates, including CallNow Inc., substantially secured by distressed municipal bonds related to a financially struggling horse racetrack operated by CallNow in Texas. By the way, in 2006, CallNow became the largest shareholder of Penson. However, when the margin collateral plummeted in value during the financial crisis of 2008, Penson failed to liquidate Hall's and his affiliates' collateral to avoid realizing large losses for Penson. Instead, Penson increased the amounts of margin loans to these customers, sort of like doubling up. The SEC claimed that Penson should have recognized losses on the loans as early as 2009, but did not do so until 2011. Thus, Penson's broker-dealer and public company required financial statement filings with it for year-ends 2009 and 2010, as well as for some other periods, were not in conformity with generally accepted accounting principles, said the SEC. And finally, the Commodity Futures Trading Commission charged Robert McMahon with orchestrating a scheme to allocate better-priced futures trades to himself and poorer-priced futures trades to a customer. The alleged transactions involved natural gas futures contracts traded on the New York Mercantile Exchange during July 2010. To settle this matter, Mr. McMahon agreed to pay a fine of $171,800 and be barred from trading on any CFTC registered entity. Previously, Mr. McMahon was ordered by CME Group Business Conduct Committee to pay a fine of $100,000, disgorge profits of almost $179,000, pay restitution of almost $189,000, and be permanently barred from trading any CME Group product in connection with similar activity, not only on NYMEX, but the Commodity Exchange, Inc. It would not be surprising if someone questioned the appropriateness of the Commodity Futures Trading Commission bringing this Me Too enforcement action against Mr. McMahon, given the CFTC's limited resources and the fact that the CME Group had previously prosecuted and sanctioned Mr. McMahon for apparently the identical conduct and more. I have more to say on this seeming double jeopardy. Check it out on the article version of Bridging the Week at www.bridgingtheweek.com. Well, that's it for this week's issue of Bridging the Week. As always, there's more information in each article and more articles on the article version of Bridging the Week on the website. Check it out. Until next week, this is Gary DeWaal. Have a great week and ciao!